Welcome everybody to another episode of Taxel Insiders. With me today, I've been lucky enough to snag Matt, Abby, and Randy Saunders from Nelson Mullins. You guys have been great guests for us in the past. So welcome again, guys.
Hey, how are you doing today? It's good to be back.
And we had I don't know, I'll say a kind of a fun topic. It's a unique topic that not everybody in this industry even knows exists, but we just got done talking about some of the things that we've seen or practices that we've seen in the industry that are kind of cringeworthy is maybe a good way to put it. And so why don't we talk about some of those do's and don'ts, and really the what we're going to hit on today is the secondary market transactions, or to make sure we're on the same page of primary auction, at least in the terminology I use. Primary auction is going to the county, the municipality, or whoever the taxing jurisdiction is, buying it from them directly. That's the primary market. And then there's a secondary market, which is somebody else went to the auction and purchased that tax lien or tax deed and is now selling it, basically from one investor to the next. And now it becomes a secondary market transaction. And I guess one of the myths is that that's not legal, and that's not true. It is legal in most states. There are some states where you can't do it at certain parts, or maybe you can't do it at all. But in general, a secondary market transaction in tax liens is certainly doable in most states. But there's a lot of practices out there that are, well, you definitely want to avoid. And I guess to start the conversation off, Randy and Matt, kind of hit on some of the things that we do or help with, and then I'm sure you guys will have further insight into some nightmare stories that you've heard, or things that you think buyers and sellers alike should avoid. But some of the practices that we've seen out there that make me cringe is, depending on the size of the transaction, purchasing and sending money to a seller without ever getting whatever that collateral is, either in conjunction or beforehand. And we've even heard of some transactions being in the millions of dollars, where the buyer will sell or wire the money to the seller, and then they wait, right? And I've received calls of hey, do you know so and so? I wired them X millions of dollars a few months ago. I still haven't seen my certificates, and that's kind of a nightmare scenario from my perspective, because where'd the money go? When am I going to get the collateral? Word of mouth is great. Signed documents are great, but it's always better to have a neutral party in the middle that either holds the funds, holds the certificates, or in our case, we do both, right? So that everything's there, and then you can disperse in both directions. That's just one example. But what we were talking about before we started recording here, Randy, is some of the things that happen, at the very, very beginning of a transaction, which is understanding, why is the seller even selling this, and at a price that makes sense. And maybe the easiest kind of way to talk about this is just use an example in Kentucky, and why pricing in Kentucky is so different, right? So can you kind of elaborate on that a little bit, of why pricing and reason for selling should definitely be at the forefront of any conversation on the secondary market?
Yeah, and so when we look at, we term, when you go to the actual sale as the investor, we call that the original source acquisition. And when you're doing original source acquisition, you understand your business model, you understand what you're trying to accomplish in that state. For instance, as we've talked about, on other episodes, in West Virginia, you're going after property that you can ultimately, obtain and maybe create either a resale or a rental market. In Kentucky, you're doing it for servicing and redemption. But you're going into that market, you're identifying properties that and liens that fit your business model, and you're acquiring those, and you're developing your portfolio. When you look at the secondary market, the number one question that I want my clients to figure out, from the outset is, why are they liquidating this portfolio? Are they going out of business? More likely, are we in a position where they've taken the cream off the top And these are either some of the more troubled assets that they have, or even worse, they're dead in the water. In Kentucky, you've got a situation where you get 10 years plus one, because in that first year, you've got to have a payment plan, and you can't move. And then you've got 10 years before the lien dies. So if you're looking at that portfolio and you're asking, the seller, why are you liquidating in Kentucky? Probably the most common answer would be like, oh, we're just getting out of that market. We're going into other markets. Now, truth be told, what they've probably done is they've probably maximized the return on investment from the portfolio they had, and they've made an economic decision that any more money they throw after this is they're not going to be able to recoup. So let's sell it on the secondary market. Let somebody else go after it. If you look at that, you want to look at the liens that are in place. I had a client before that purchased a significant amount of liens as part of a larger portfolio in one county, and those liens were ultimately, and I think even prior to the acquisition, they had been determined to be invalid because they were refuse liens, and so that was a big issue. So on their face, they looked okay, but a little research into that county and these liens and how they came about, and simply talking to the county officials would have demonstrated that. The other issue that I think you really want to look at is not so much, doing the research on the liens that you're purchasing, but if you're looking at the portfolio and the liens are 7, 8, 9 years old, that should set off a lot of alarms. Obviously, if they've been down that road, they've sat there, there's a reason. There's 120 counties in Kentucky, so it is a good example to use for this purpose, but there are some jurisdictions that are very difficult. There are some jurisdictions that the judiciary does not approve of this, or is not as supportive of this. Therefore, they may not be moving to take those to sale in those counties. It could be a situation where they don't have the initial statutory compliance that they need. Did they send out the required letters? Did they do the payment plan? Did they do all the things that they needed to do to be able to enforce these? The other issue too in that situation, especially in Kentucky, you're purchasing a lien every year. If you go back to that sale the very next year, you have priority and you can repurchase a lien on that property if it comes up again. But if not, it goes to sale. So if you've got a portfolio that has 6 or 7 years age on that lien, you could have another 4 or 5 people in front of you. Then what happens is when you go to a small county, you're going to move it through the judicial process, which is going to have costs. You're going to have to add those other investors to that action, and it's going to go to sale, and each of those liens is going to have to be paid off through, and it's a pro rata distribution. So, again, you're looking at a situation where even if you take it all the way through and you can monetize it, it is that property going to sell and be sufficient to pay off both the county for their expenses and all the other investors in front of you. So there's a lot of, that's a good example. And again, we're just touching some of the high points. But if I had a client come in and say, here's a Kentucky portfolio, what do I need to look at? You're looking at the rationale for why they're selling, and then you start to look at, the other variables that we've discussed.
And I think you hit on an important piece, which is knowing what to look for, right? And it's one thing if you're buying a secondary market portfolio in a state that you're already active in, you're very familiar with the do's and don'ts, and maybe you can navigate that sale without counsel or engaging an attorney to help you. But if it's a new state, we always recommend, and certainly anybody that's getting in the industry should certainly reach out to an attorney that understands all of those aspects. I don't know if everybody caught it, but you just rattled off probably 5 or 6 things that are unique to Kentucky that may or may not be applicable to other states. And just one example is old liens, right? In Kentucky, 8, 9 years old is getting old, but it's still enforceable. 8, 9-year-old liens in Florida are worthless, right? So that little nuance there is the difference between a portfolio that might make sense purchasing at a certain value and a portfolio that would be an absolute waste purchasing any of, right? And so knowing what to look for is certainly a golden rule, if you will. I'll say that's number two. Number one being, using a neutral third party for the transaction. And then, I guess.
If I could just, because one of the things you just mentioned, I think is a really good point, because we get people that reach out a lot that are debt buyers.
Mm-hmm.
And so, when you look at that, there are still people that are by debt portfolios, even if they are past the statutory time, because they in some circumstances, they may still try to monetize those. But in jurisdictions, even in Kentucky, if it's past that point, or in Florida, if it's past that point, this is an entirely different situation than a debt obligation. This is a lien, that has a certain lifespan, and at the end of that lifespan, it's gone. So you have nothing if you don't take your action in that time period. And so, that's a great point that you're talking is just the distinction between what is that lifespan in Kentucky, what's that lifespan in Florida, and then for somebody that would be new into this industry, but that may have, a lot of experience in buying portfolios, and especially what we classify as debt portfolios in other industries, they may not appreciate that, that distinction.
Right. Well, and I guess I'm kind of coming up with these golden rules as we go, since we didn't lay these out ahead of time. So everyone's learning as we make these up. So obviously using a neutral third party, engaging an attorney or counsel in a state that you're not as familiar with. And then I think number three is definitely understanding what you're buying, right, and doing your due diligence, right, and that's a very large category. But I think two key components in there is, one, is it transferable, right, and two being, is it enforceable, right? And Matt, I want to ask you, kind of specific to South Carolina, is it transferable? Because I believe there's certain stages in the life cycle of going from sale through actually having insurable title, at the end of the quiet title process, where even if you wanted to transfer that tax deed, we'll call it, you either couldn't or you could, but you're gonna have to start over, right? So can you speak to that a little bit, or at least how that works in South Carolina? Obviously, this doesn't work the same in every state, but at least you can help us understand the different nuances in South Carolina.
Yeah, for sure, and not just with South Carolina, but all over the place. You want to make sure that you are properly papering your transfer, your agreement that you have between the seller and the buyer. And when I say properly papering it, I'm not just talking about the agreement and what terms need to be in that initial agreement. I'm talking about what you get once you close. So usually the distinction that we see is between real property and personal property. So a real property interest, that can only be conveyed by a deed that meets the statutory definition and requirements for a deed. And you got to know when that type of document is used, when deed's used, versus some other type of, maybe a bill of sale or something of the sort, an assignment of rights or something like that. So in South Carolina, for example, once you have the tax sale, the actual auction of the property, that lien will stay out there for a year. And during that year period, the county is the one handling not only the notices, but the redemption. During that period, you just have essentially a tax sale certificate. It's a tax sale receipt that you get from the county. You cannot convey that by deed. That's got to be something that's conveyed by bill of sale, an assignment. The counties will require some sort of notice, usually on their particular form, for you to be able to transfer that interest to a third party during that 1 year redemption period. And then once the redemption period ends and the tax deed is issued, then it can be transferred with another deed. But the county is going to go based on whoever had the rights at the end of the redemption period. That's who they're going to put on the tax deed. So knowing where you are in the process is important, because that's how you know how to paper up the deal, which then is going to impact your ability to enforce later. We've seen situations, unfortunately, where people purchase on the secondary market, and they buy not really understanding the full process in that particular state. And so they've got a nice purchase and sale agreement, or bill of sale or something like that for this whole portfolio, and it's got this great spreadsheet attached to it that has the information about all the properties. But the problem is they then go and record quitclaim deeds for each one of those properties in all the counties where the interest is, where the property is located, but no tax deed's been issued. And so that quitclaim really is ineffective to transfer any interest. So then when they retain us to go and try and do quiet title, we say, well, that quitclaim's great, but that doesn't do what you need it to do. That hasn't transferred the interest, so we can't get you the tax deed, we can't file the ejectment or quiet title action. So knowing your state and knowing what you need as far as the paper goes is important. And then there are other aspects that are going to be state specific as well that you're going to need to take into consideration. Are there state specific forms that you're going to need for these different conveyances? For example, South Carolina's got something called an affidavit of true consideration that you got to record with every deed. So if you're at the part where you're buying on the secondary market and you do have real property involved, you're going to need to make sure that you've got one of those for each of the transactions. Or you have a non-resident withholding affidavit, and that's going to be required as part of this transaction to ensure that the seller hasn't got some kind of deed from the Department of Revenue that would attach upon the sale of these assets, especially if they're winding down their business. So knowing how to properly paper it is hugely important.
So it's not just, is it transferable, but how you transfer it, right? That's key. The other one that I mentioned, and Randy, I want to pass this over to you, is, is it enforceable? That's a big topic, right? But just because they may have a lien on this property and the collateral looks great and everything looks beautiful, right? It doesn't always mean that it's worth purchasing at the end of the day. Can you elaborate on that a little bit?
Yeah, so we'll jump back over across state lines back into West Virginia for a minute, and so there, you purchase your tax lien, and you've got 18 months, and during that time period, you got to do a title search, and notice has to go out to anybody who has an opportunity to redeem. So then, at the 18-month period, you can walk into the county courthouse, you can request a tax deed. Okay, that tax deed issues. So say it's your first time in West Virginia, you've got somebody that's got a portfolio of tax liens, maybe somebody's got a portfolio of tax deeds. And you're thinking, oh, wow, okay, this will be good. I want to acquire some properties. If you didn't go through the process and you didn't provide the information to the auditor, and you didn't get proper notice out, that's going to create a problem. If you've got the tax deeds, right, and you think, oh, wow, I've got a deed to a property. What does that mean? Well, in West Virginia, the due diligence period for purposes, for due process occurs after the tax deed is issued. Mm-hmm. So at that point, you have 3 years to challenge. So just because you have a tax deed doesn't mean that it's not challengeable and can't be set aside. So I think the worst case scenario would be, I've got this tax deed. How ironclad is it? Because enforceability in West Virginia, you take that tax lien in, they'll issue the tax deed for you. This is no big deal. But the issue is then you've got 3 years for anybody who may have some type of an interest to step forward and redeem. And so imagine if you paid for that portfolio because you wanted to get the tax deeds at that time, and obviously there, you're going to pay more of a premium for a tax deed than you are for just the tax liens. Didn't do your due diligence, didn't look to make sure that they complied with all the statutory requirements prior to obtaining the tax deed. You sit on those, and all of a sudden you get a suit to set aside, and what they would have to do at that point is simply pay the redemption cost, and then they get the property back. It's a big difference from what you thought you were purchasing. Huge difference, and you could take a huge bath, on that. The other issue that I was thinking about, I'll jump into enforceability, but this ties in because the payment plan requirement in Kentucky is so unique. And so if you're coming in, you have a statutory obligation to offer at least one payment plan. You can do more, but you're required to do one. So say you're looking at it and we have the opposite problem. that we talked about earlier, they're not old, but they're brand new, right? And so you think, wow, I'm buying all of these new, they're a year or two old. It's going to be fantastic. Are you set up to take over the payment plan process and to continue it? Because obviously, if you're going to get that portfolio, you can't just get that portfolio. You need to get all the information basically about the servicing of those payment plans to make sure that you continue to make those enforceable. Because if you don't, or it dies up and you file an action, to take it to sale, and you show up in court, and they're going to be like, well, judge, I was paying, and I had a payment plan, and I kept paying that, and I paid everything off, and I asked for a release, and I never heard from them. Here's all the money I sent. And judge looks at you, and you're like, I didn't even know that there was a payment plan, and I bought it from somebody else. And so they were paying the original purchaser. You're done. The judge is going to be like, well, this person paid to redeem. I mean, from a practical perspective, I'm just going to say most judges are not going to find in your favor. And that if you've got a resident taxpayer in that county who's made payment plan, or maybe he stopped paying because they couldn't figure out who they were supposed to pay. So again, there's so many different ways that you can have issues arise that affects your enforceability that go so far beyond just the paper.
And having in the agreement some sort of provision that requires, continuing cooperation, or requires access to files and things like that within, 48 hours or something upon request. Those kind of things can help protect you and have access to those records about the payment plans. Or if you had to send enforcement notice, let's say, for instance, in Alabama, where you're sending enforcement notices to lien holders under the old tax sale scheme, having copies of those or access to them if there's a challenge, that's going to go a long way towards enforceability.
You mentioned, Brian, too, one of the clients that had mentioned the fact that, they paid the money, but they didn't get their paper back, their certs back. One of the other things too, though, is depending on what state you're in, I want the data for the servicing. I also want, if I'm required statutorily to send certain correspondence out, if I've got to send a 45-day letter out, 50-day letter out, like you do in Kentucky, I need that whole servicing file. So I don't just need, so depending on what I'm going to need to enforce these down the road, I need to make sure that I've got all that as well. And before I release anything, I want all of that, or at least make sure the third party has it. Because to Matt's point, it is absolutely necessary to have that condition in there so that there's continuing cooperation. The problem from a practical perspective is if I go back 2 years later and I ask for a 45-day letter from a purchaser that I got the liens from in Kentucky, they may not have it, or you may not find it. I want to know that up front, because that's gonna affect my ability in front of the circuit court judge to enforce. And quite frankly, that goes back all the way to our first question of pricing, because again, some of that could be a risk tolerance question. If you're in a redemption, if you get a payment plan, this type of stuff, and you may be pricing it on the fact that I've got an active taxpayer plan in place, and so I'll pay X amount for that, but I've got enforceability questions, so I need a deeper discount. So all of the stuff we're talking about can go directly into us helping you negotiate your purchase price for this as well.
And I'm gonna hold the pricing it appropriately for probably another episode, because we could spend quite a bit of time talking about that, because that's a big topic. But I think I found golden rule number 5, and I wanna run through those real quick again. But before that, you'd mentioned on the different types of notices, and I was just going to use Illinois as an example of the lien. Signing the lien is just one piece of 3-piece pie, which is actually less complicated than many states. But right after purchase, you got to send a take notice in Illinois, and you better get a copy of that. And then Illinois has always had this at least 2 year, but you can go 2.5 year if you file for an extension. Or I think you can go up to 3 years if you file an extension, right? And if you don't have a copy of that extension, now you need all 3 of those things in order to make that lien enforceable. If you're missing any of those pieces, that lien, even though it's been transferred to you, is absolutely worthless. So, making sure that it was transferable and transferred correctly is key. But golden rule number 5, I think what Matt, you touched on, I think we want to definitely highlight is making sure the agreement has the provisions in it that get you what you need to make that transaction viable, right? Not only what's needed at the point of sale or at that point of transference, but Matt, as you mentioned, you have the ability to go back and continue to work together, right? Making sure that, hey, I'm buying this from somebody that isn't trying to get one over on me, right? I'm buying it from somebody that ultimately is willing to help in the instances, because they are inevitable that they come up. Hey, I thought we had everything, but I'm missing a signature on this one, or this, this copy was fuzzy. Can you help me fix this, right? And it always helps to have those provisions in the agreement to make sure that stuff happens, right? Better safe than sorry. So I don't want to cut us off entirely, but I think we're going down a great path into talking about pricing, and we'll reserve that for another day, Randy, if that's okay. But
No, that's perfect.
reiterate our 5 golden rules we came up with really on the fly today. 1 is using a neutral third party for the transaction. 2 is engaging a counselor attorney in the state or states that you're not familiar with, or if it's your first transaction in a state you are familiar with, I still recommend doing that. 3 is making sure those liens are transferable, right? And that varies, as Matt pointed out, that varies depending on the stage that lien or tax deed is in. 4 is making sure it's enforceable. And there's a lot that goes into that, and making sure that at the end of the day you can enforce that and you will at least get your return out of it. And 5 is making sure you've got the right documentation in place, the right agreement in place that allows you to do everything you need to throughout the life cycle of that transaction, then ultimately in trying to enforce it. So those are we didn't even come into this with the goal of coming up with 5 golden rules, but it was a beautiful outcome of of our discussion. And I think we'll probably come up with more golden rules when we go to pricing it, because I think that'll be a great discussion as well. But Matt, Randy, I want to thank you guys again for joining us, providing your insight into these transactions, which you guys have way more experience in than myself or anybody else that's probably listening. So thank you again.
No, thank you. We appreciate it.